Well, my dear students, I welcome you all to our week 2 lecture. This week, we are going to talk about a few sections from chapter 2. So if you recall, last week we talked about legal foundations from chapter 1. As I can see, some of you are actually carrying your text with you. I really appreciate this. So I try to mention the specific chapters, specific sections from the textbook. And today when I will be delivering my lecture, I will try to refer a few images from the textbook, few tables from the textbook, because we need to know where these things are, where all these resources are. Because at the end of the day, we'll be sharing so much information, so many different legal jargons and terminologies. You may feel overwhelmed. That's why at least you need to know where I can find them, where I can look for them, right? So today we are going to talk about section 2 and section 3 from chapter 2. So the first thing we're going to do is we're going to learn about the court system in Australia. Now you can ask me, Tanzim, we're not going to practice law, right, in the court. So what's the purpose of learning about this court system in Australia? Hey, even if you work in a company, even if you run your own business or work in a partnership, whatever type of business you are involved in, if any dispute happens, you must have a very fundamental idea where I can get my remedy from, where I need to go for a relief. So that's why today we will be talking about different court system in Australia, jurisdictions of different courts, the hierarchy of Australian courts, and the next segment after the break will be about doctrine of precedent. Last week when we introduced the common law legal system, we mentioned that it is based on case laws. So today we will talk about this doctrine of precedent in detail. So that's the plan for today. Let's start. Again, this is the Australian map I wanted to share with you guys. And last week you gave me the correct answer that how many states we have in Australia? 6 states, right? 6 states. And how many territories we have? 2 territories. So it's a reminder for us. These 6 states and 2 territories, in total 8 jurisdictions. Today I have separate lecture on jurisdictions, separate slides. If you have gone through my lecture slides, you will see I will be talking about jurisdictions in a moment. But whenever I will be talking about jurisdictions, by jurisdiction I will be referring these 8 jurisdictions. 6 states and 2 territories. Does that make sense? So we need to keep that map in our mind all the time. So the first topic we are going to talk about is jurisdiction, but we are going to talk about jurisdiction of courts. Now you can ask me, Tanzim, what does it mean? In plain English, jurisdiction means power. So basically we're going to explain or narrate what are the powers of different courts in Australia. If you know which court has what power, only then you know, okay, for this purpose I need to go to that court. For business purpose, I need to go and visit this court. For contract law breach, I need to visit that court, something like that. So jurisdiction of courts means power of a court. The literal meaning of the word jurisdiction is power. Like, in a simple way, I can put it, as I am the unit coordinator of law 1100, right? So if anything happens in this unit, who has the ultimate authority or power to resolve any dispute regarding this unit? Say, on the Canvas side, the assignment submission date is 12th of May. Somewhere else, someone heard that the submission date is in May. So who can resolve that dispute? Because I have the power, right? There are certain things as the unit coordinator, I do not have the power. I have someone above me, course coordinator. So the course coordinator has certain specific powers which I cannot implement. The course coordinator will apply or exercise those powers. Say some of you may be enrolled in an accounting unit, for example. Do I have any power to resolve any dispute regarding that accounting unit? No. So regarding the courts, in Australia we have so many different types of courts. In a moment I will share the list with you. I will go through each of those courts. The same thing is applicable. You will see that one specific court has very specific power. It cannot, exercise other different types of powers that other courts will apply. So when we are talking about this power of courts or jurisdiction of courts, we will have our discussion based on these three headings. First one, we're gonna talk about, whether the court has the authority over any territory. So based on the territory, there will be different types of jurisdictions. Then based on the subject matter of the case, you will see that different courts have different jurisdictions. Then which court will hear my case first? Based on that, there will be different courts having different jurisdictions. So these are the three broad types of jurisdictions we're going to cover in our lecture today. I want to start with the first one, that is territorial jurisdiction. So in Australia, we have two main court systems based on the territory. So when we're talking about the territory, you see we are referring to the Commonwealth and at state level, right? So if you recall our last week's lecture, we learned about the historical background, how we got the federation, the concept of Commonwealth. Before that, we were, colonies, or British colonies. So since when we got this Australian Federation, we have our Commonwealth. So at Commonwealth level, the court that will implement any Commonwealth legislation, or statutes, or law via which courts? These courts are known as federal courts system in Australia. We have three courts under that court system. At state and territory level, each state and each territory, they have their own court system. So this map we are talking about, at state level, we will go through different types of courts and we will see that those courts have a certain power to exercise. So based on territory, these are the two types of court system we can think of: federal court system and state and territory court system. I have separate slides, at least 4 or 5 slides, where I will explain what are those federal courts that we have. What are their specific powers they enjoy, and for what type of cases we can go to a federal court. I will explain them in a moment. The same thing I will do for state and territory courts. So at a state level, what are the different courts we have? When we visit, what type of courts? Again, I will explain those, but not at this moment. So this is a figure I have taken from your textbook, which actually shows that at the top of this, structure, the court system, we have the High Court of Australia, right? So that is the highest court sitting on the top, and then all the green courts just below that, High Court of Australia. As High Court of Australia is the highest court, the other courts are sitting below High Court, but they are the federal courts, as you can see. So when we will be talking about the state court system, I will request you to focus on the right side of the image. These red boxes, it's talking about the state Supreme Court, state intermediate court, and state magistrate court. So these are the three court systems I will cover in my lecture today, and I can guarantee you whatever I do not cover in my lecture, you will have no question from that topic. Does that make sense? So this table will help you to see where the state courts are sitting, and we will explain each of those state level court systems in a moment. Now, the second type of criteria based on which we can have different types of courts jurisdiction is based on the subject matter of the case. Again, last week when we talked about classification of case, classification of laws, we have learned that based on the content of the case, it can be a criminal case or it can be a civil case, right? So if there is any theft, murder, dacoity, rape, all those types of criminal incidents happened, the cases are known as criminal cases. And in a moment I will share with you that only certain courts can hear criminal cases. If a court has the power to hear a criminal case, we say that this court has the criminal jurisdiction. Criminal jurisdiction means it has the power to hear a criminal case and give punishment to the offender. Does that make sense? Again, there are different types of subject matter of the case. It could be there is a contract between two parties and someone has breached that contract, or there is parties who are in a dispute based on a property, based on, most of the time, business related matters are covered under civil matters. So if the dispute is regarding any contract, tort, dispute regarding business, all those things, they will be covered under civil jurisdiction. They are civil cases. And again, today we will learn which courts have civil jurisdictions. That means which court can hear a civil case and give some remedy. So there are two different types of jurisdictions. One is known as criminal jurisdictions, and another one is known as civil jurisdiction. But this classification we are doing based on what? Based on the subject matter of the case. So, just to recap, we first made the classification of jurisdictions based on the territory. At the Commonwealth level, there are federal courts which deals with Commonwealth legislation. At state and territory level, we have a separate court system and they have their own jurisdiction. So this jurisdiction is based on the territorial jurisdiction. Based on the subject matter of the case, we have two types of jurisdictions, criminal jurisdictions and civil jurisdiction. Now, I will pay a little bit more explanation. I will share more explanation regarding these two jurisdictions. So, while we are talking about criminal jurisdiction, we need to understand what do we mean by a crime. A crime is an act or a conduct by a person against the interest of the whole community. For example, shoplifting, theft. These are examples of crimes, and law considers that these offenses happens not only against one individual, it happens against the whole community. Whereas a civil case is brought before the court when one individual or an organization commences a case or action against another individual or against another organization. For example, the contract was between two people or maybe three people, right? But one of them has violated the terms of the contract, and that's how they have ended up in a dispute. So in that situation, one person will bring a case against another person, or one person will bring a case against two other people. So, most of the business-related cases fall under the category of civil jurisdiction. Now, this is the figure I have taken from your text. If you have the text, you can go to that figure 2.10. So chapter 2, figure number 10 says, who are the parties of a civil litigation? The person who brings the civil case in a court is known as a plaintiff, and that is a legal term. We know if it is a legal term, we will not be able to paraphrase it or change it. So, plaintiff is a person who brings a civil case, and against the person who brings that case is known as a defendant. So again, if we forget the legal terms, who is the plaintiff, who brings a civil case, what's the legal term for them? If we know the figure, okay, in our textbook, that's where it's been mentioned, you can double check and then you can put them or mention them in your answer. So plaintiff and defendant, that's what happens when someone is bringing a civil case. Say Mr. A and Mr. B. Mr. A has brought the civil case against Mr. B. So what's the legal term we're gonna use for Mr. A? Plaintiff. And Mr. B will be known as defendant. So there is a judge who heard this civil case. So that court had the jurisdiction, civil jurisdiction, and gave a remedy to Mr. B, the defendant. But the defendant is dissatisfied with the judgment. What he can do then? He can make an appeal based on that judgment to a higher court. So which one is a higher court? We don't know yet. We are just we are just introducing the parties of a civil case. So if the defendant tries to take the matter to a higher court and makes an appeal, then there are two parties. Again, right? One party is bringing the appeal and the court will hear the appeal against another person. The person who will bring the appeal will be known as the appellant. Appellant means who brings the appeal to the court. And who will respond to that appeal will be known as respondent. Right? So it's not like that always the plaintiff will become the appellant. It can be the other way around. Whoever brings the appeal in the appeal court. So from figure 2.10 and figure 2.11, we have learned who are the parties of a civil case. Right? Now, which court will hear the civil matter, that is actually determined by specific acts, specific legislations, and every state, they have their own piece of legislation for that. Law 1100 is a very foundational unit. I'm not going to share the detail of that civil code and civil procedure legislation. What I'm going to share with you though, if you have your text with you, could you please go to table 2.1. Table 2.1. You will find out something like this, and all the states, New South Wales and other states will be mentioned in that table. As we are in Western Australia, I will request you guys to pay attention to the jurisdiction of which state? Western Australia. If you understand this one state, the jurisdiction of this state level court system, you will understand the rest of the states as well. So pay attention, pay close attention to the Western Australian civil courts cases. So what this table is sharing with us is that in Western Australia, we will have different types of courts which will deal with civil matters, civil cases. This one is known as a magistrate court. The other one is known as a district court. It is higher than a magistrate court. Then we have a Supreme Court. If we go back to this list, you see the Supreme Court, district court, magistrate court. Are we all following? At state level, in WA, these are the three courts we are referring here. Let's go back to that table once again. So this table says the Magistrate Courts of Western Australia deals with civil cases, but there is a limitation. This is this Magistrate Court where all the civil cases just start, right? It is sitting at the bottom. The Magistrate Court is sitting at the bottom of the court's hierarchy, and it deals with civil cases up to where the claims are up to $75,000. Any civil case where the claim amount someone is asking, the plaintiff is asking, say, $40,000 remedy. A magistrate court has the jurisdiction. A magistrate court in Western Australia has the power to hear that civil litigation or civil case. So highest $75,000 up to that claim that, the magistrate court in Western Australia, they will be here that civil matter. But if a plaintiff has a case, civil case, where the claim is above $75,000, say $80,000, where that plaintiff will file the case? Can he file the case in the magistrate court? No. Why? Because magistrate court doesn't have the power, doesn't have the jurisdiction to hear a civil case where the claim is above $75,000. Does it make sense? So the plaintiff then needs to go to the district court, because district court has a jurisdiction to hear civil cases where the claim is from $75,000 up to $750,000, right? So if the claim is up to $80,000, where the plaintiff will go with that civil case? District court. But if the plaintiff has a claim which is huge, more than $750,000, say $800,000 claim, where the plaintiff will file that case? Supreme Court. So you see this table, you all have access to this table. I'm just saying you need not to memorize this information, but you need to understand this information. What is this table saying to us? What message this table is conveying to us? We need to understand that. So during the lecture, this is what I am doing. I'm clarifying the concept. Hopefully you will understand this. If not, I'm happy to repeat again. So this is what we mean by the civil jurisdiction. It is so where it is written, like which court will have this jurisdiction, like which magistrate court can hear a civil matter up to $75,000. Where it is written, what is the source? There is a legislation, there is a statute in Western Australia, Civil Procedure Act we have. Based on that civil procedure legislation, all these different courts have their different jurisdictions. We are not going in detailed discussion regarding that statute, but this is what we need to learn, that which court has jurisdiction regarding civil claims, right? Any question regarding civil cases? Yes, please.
So just say for personal injury law, just say one of your cases is more than $750,000. Go to the Supreme Court, the state district.
If it is more than $750,000, it will go to the Supreme Court.
Okay.
The district court will hear from $75,000 up to $750,000. So within that limit, if the claim falls within that category, only then the district court will hear the case. Anything above, it's a very serious matter.
Yeah, because it says here personal injuries unlimited, so I thought maybe it might be restrained to just district.
Yeah, there are other subcategories, but I'm talking about the first one where the claim is between $75,000 and $750,000. Say if it is a minor case, this is the limit, $10,000, and it goes to the magistrate court. So there are a few other subcategories based on the type of the cases. But broadly pay attention on the claim amount. If the claim amount is below $75,000, it goes to magistrate court. Above $75,000 but below $750,000, district court. And if it is $750 plus, then it goes to Supreme.
So in that case, if it's just say someone's permanent impairment where it's like $1 million, it will go to Supreme.
And these are very serious matters. So we don't expect that a magistrate will deal with, such a case, right? Okay, no worries. So after talking about the civil jurisdiction, let's now pay attention on criminal cases. And now we will explore which courts can hear criminal cases. First thing we will do, we will introduce the parties. If someone brings a case to the court, that's the person who is initiating the case. In a civil case, we have learned the name of the parties were plaintiff and defendant, right? But in a criminal case, the situation is slightly different. If you recall, I already mentioned, when we talk about a crime or criminal case, these offenses or crimes, law considers that it has been committed against the whole community. So who brings the case? The Crown will bring the case. The criminal cases always starts with the Crown versus someone. Say there is a theft case or a shoplifting case. Say Mr. X shoplifted something from David Jones or somewhere, but this is a theft. We have different legislations where the definition of theft has been explained. When we can define something as a theft, when we can say this is a crime of rape, when we can say this is mutual consent, all those things have been explained in a criminal code. And again, I'm not going in detailed discussion of this code. My discussion will be focusing on the court system only, okay? So whoever has committed a crime, he or she has committed the crime against the society. So the Crown will bring the case against whom? Against Mr. X, because Mr. X has committed the shoplifting crime or a rape crime, whatever. Right? So the parties in a criminal case will be known as the person who brings the case is the Crown, or known as the royal. R represents the royal versus the accused. So in the long run, when you will be studying more and more case laws from your textbook, you will see by the name of the case you are capable enough to identify whether it's a criminal case or whether it's a civil case, right? If the name of the case is Mr. Solomon versus Donahue, something like that. These are the two people. So Mr. Donahue filed a case against a Mr. Solomon or something like that. So if the case is between two parties, is it a criminal case or civil case? Civil case, right? If the title of the case is R versus Smith, it's a criminal case, right? Because R means royal. The crown has brought the case. That means it's a criminal case. So the courts where the criminal cases will be heard is determined by the code or the act of that state. For example, in South Australia and Victoria, they have a Crimes Act, but in Western Australia and in other Australian jurisdictions, a criminal code sets out like what is the criminal jurisdiction of which court. In a moment, I will go through which court got what type of criminal jurisdictions. As we have already mentioned, that the Crown brings the case against the accused person. So it is the burden on the Crown to prove that a crime has happened, and that is the responsibility of the Crown to prove in the courtroom. There is a legal term we are going to use. I have highlighted that legal term with red ink on purpose so that we don't forget it. In a courtroom, when a court is hearing a criminal case, the burden of proof is on the royal. That means the state must prove beyond reasonable doubt that a crime has been committed by the accused person. If the case cannot be proved beyond reasonable doubt, if there is some doubt, if something, then the court will not punish the accused person. They will grant acquittal from that claim that he was a criminal or something like that. Why so? Because the standard of proof is a very higher standard of proof when we are dealing with criminal cases, because the outcome of a criminal case is punishment. The punishment could be as serious as a death penalty in some countries. It can be lifetime imprisonment. It can be, imprisonment for 1 year, 2 years or whatever. It can be a huge amount of fine, or it can be a combination of both, fine plus imprisonment, right? So these are the consequences which are really severe. So the case must be proved beyond reasonable doubt in the court. Does it make sense? Whereas for a civil case, we do not maintain such a huge standard of proof. The standard of proof for a civil case that we maintain is balance of probabilities. If you recall last week's video where we showed civil cases versus criminal cases, you have noticed that there is a balance, and even the plaintiff, if they could prove the subject matter even by 51%, the court is convinced. It is known as balance of probabilities. Who has proved their case based on the balance. Why so? Because in a civil jurisdiction, the outcome is a remedy. The remedy is like the court will calculate the actual loss. If there is a breach of a contract, say the actual loss the plaintiff has suffered, say it's $1,000. The court will calculate that loss and grant that remedy as a judgment. So the outcome of a civil case is not that severe like the criminal cases. The punishment that someone gets from a criminal case, it is not the actual calculation of the loss. For example, there is someone who actually breached the red traffic light. It's a crime, right? So there is a fine imposed. That fine will not be the actual calculation of the loss. Maybe the actual loss is only nothing, zero. Just someone broke the traffic light. There is no injury, nothing. But the fine can be $500. Even in some cases, maybe the actual loss is just $500, but the fine imposed by the court can be up to $5,000. So a punishment is always a bigger amount, a severe consequence. Why? So that it has a deterrent impact. No one else in the society dares to do the same type of crime. So that is the outcome, ultimate goal that a court tries to achieve from a criminal case. So the two types of standard we have talked about, and the legal jargons we have to use in our writing is, in a criminal case, beyond reasonable doubt, whereas a civil case, that is in a balance of probabilities. Another thing I have to mention under criminal jurisdiction is the standard of proof for a criminal case is way higher than a civil case. It is also difficult to prove a case in the criminal case. Why? At least two things the Crown must prove against the accused person. First thing is the mental element, which the Latin term the lawyers use is mens rea. That means, say there is a criminal case of a murder. Someone has been accused, Mr. X has been accused for murdering someone, and the state has brought a criminal case against Mr. X. In the court, beyond reasonable doubt, it has to be proved that Mr. X had the intention, the mental element of committing this murder. The next element they must prove in the court beyond reasonable doubt is the actus reus, that means the actual action. That means Mr. X has actually committed the murder. Same thing, shoplifting. The first thing in the courtroom, it has to be proved that Mr. X had the intention to do this shoplifting, and there has to be some proof beyond reasonable doubt that he or she has actually committed the shoplifting thing. So again, it's a complicated process of proving the case in a court, whereas in civil matters, most of the time it will be based on the documents, based on the witnesses. The civil cases will be proved. So I have discussed two types of jurisdictions based on this subject matter. So a court will have civil jurisdiction, and which court has what type of civil jurisdiction, based on the table you will be able to answer. And the criminal jurisdiction, in a moment I will be talking about the specific courts, what type of criminal jurisdiction they have. But before that, I want to take the question.
So under the new Workplace Health and Safety Act, we now have pretty big criminal punishment. Say I go to work and I hurt myself at work. If the WorkSafe WA brings a case against my employer and it goes to the criminal court and they have proven beyond doubt, will I be able to walk straight into a civil court and have balance of probabilities they've got to pay me because if they say will they refer to that higher court's decision?
That's a good example. Let me simplify it for the rest of the class. Correct me if I'm getting your question right. So, for some cases, it is very much possible to take the matter to a criminal case. And the case has been proved beyond reasonable doubt in a criminal case that Mr. X has committed this crime. Right? So that's the first scenario. In a criminal court, the case has been proved. Criminal case has been proved. Now we are talking about the damages, the actual calculation of the loss. So can we bring the loss matter to a civil case? The legislation will outline that. Is it possible for the litigant who actually suffered the loss, can they bring a separate civil matter or not? It is most of the time specifically mentioned in the legislation, and we are not going in detail of that legislation, but it is very much possible. Regarding, but what will happen? Most of the time, say there is a murder happened. We take the matter to a criminal case, and what will be the outcome? The outcome will be very severe. There will be either life imprisonment or long-term imprisonment, right? So in that situation, that most of the time, the sufferers, their families, I'm talking about a murder case, they are satisfied with the outcome of the criminal case. But the example that you have cited, there can be situations like that where some damages are involved as well. Both elements are there, criminal element and the damages. It is very much possible. Does that answer your question?
Sort of. So
yeah.
Would the beyond reasonable doubt?
For a criminal case, that is the thing.
Will the civil court take into account the fact it's already been proven?
The civil case, a civil court will deal with the remedies. What is the actual loss? That's the calculation. So that is something. It's not related to it has to be proved beyond reasonable doubt. No, something like that. Next week we'll be talking about tort law, for example. And for tort law, you will see that there are situations where we will be calculating the actual losses. It may have some criminal implication as well. So the court determines which court will apply what jurisdiction. And in a moment, we will be talking about those different courts. We have just learned about the civil jurisdiction, right? So we have learned magistrate courts when they are dealing with a civil case up to $75,000 claim they can hear, right? I have not shared yet what's the criminal jurisdiction of a magistrate court. When we learn that, hopefully it will give you an idea, like the same court is dealing with a civil jurisdiction and a criminal jurisdiction, and to what extent they can maneuver. Does it make sense?
Yeah.
Yeah. Yes, you're welcome.
If it's already been proved criminally,
Yeah.
would the civil case not go to trial? They would just go to remedies immediately? They'd like mediate it instead of going to trial?
That's a very good question, but that's a procedural related question. Like when someone has started the case, like whether they will follow civil procedure or criminal procedure. Most of the time, if it is a criminal case, the punishment, the outcome is so severe, not all criminal cases will involve the actual calculation of the loss. The crime is against the whole community, and with the punishment, that's how it will be addressed. Only in exceptional situations there can be a case where there are both components, criminal component as well as civil component. Let me give you an example from business perspective. We are not going in detail of criminal cases because that's beyond the learning outcome of this unit. Say there is a company and the company has a director. The director actually committed some fraud, and that's how gained some money. So this is an example where it is business related and the case involves both aspects, right? The director committed some fraud. Fraud is a crime, as well as the crime he did against someone where someone has suffered some loss. In these type of situations, we have special arrangement under the legislation, and I'm saying I'm not going in detail of those legislations, in which cases both can be addressed. The criminal aspect, that means the punishment, at the same time the fine. For example, I think in 2024, there was a case in Perth where the directors actually, they were running a real estate agent's business. They took money from the clients. They promised that they will build houses and those things, but they did fraud. So there are two components here. They did fraud. The fraud element is against the whole community. They have committed a crime. And the court will give them a punishment so that no other real estate companies ever dare to do such fraud with their clients, right? So that is the criminal element of the case. Criminal case. But at the same time, from the clients, they took the money, but they didn't keep their promise. They didn't hand over the houses. So those clients suffered from loss, financial loss, right? So in that case, the court, in Australia, what happens most of the time, these type of transactions are supported by insurance. So insurance will pay these, families who didn't get their money back or something like that. In that arrangement, they will get their money back. But the fraud company will get punished. I think there is a huge amount of fine imposed against the directors of that company. So it is possible to have that criminal component as well as the civil component. But it is a very detailed and very specifically mentioned in the legislation when the court will apply both. Does that answer your question? But I'm very happy to see that you want to learn in such a deep level. So that reminds me, some of you, if you are so interested, you need to do some law units as well, where you will be learning about the Civil Procedure Act, the Criminal Procedure Acts, which actually determines what procedure to follow when. Do you have a question?
Yeah.
Yeah, please go.
Yeah, following civil judicial, you did mention that Supreme Court sits at the apex in WA. So my question is, if a plaintiff happens to think that maybe his or her court cases that may be decided or proved maybe beyond reasonable doubt, is there any other court that is other than Supreme Court in Australia that one can appeal to instead of Supreme Court?
Of course. That is something we will be talking about when we talk about appeal, right? Because now we are talking about the case jurisdictions, the jurisdiction of the courts based on the subject matter. The next classification we are going to talk about is based on the power, which court will hear the case, original jurisdiction and appellate jurisdiction. Someone can take the appeal up to High Court. That is very much possible. So I will get back to your query when we are talking about this jurisdiction. Anyone else? Any other question? Okay, so we are talking about, based on this subject matter, the courts may have two types of jurisdiction, civil jurisdiction and criminal jurisdiction. So, criminal jurisdiction, okay. So we will go through the specifications of different types of criminal jurisdiction in a moment. Let's start talking about the classification of jurisdiction based on which court will hear which case when. Then the jurisdiction can be classified into two categories. First one is the original jurisdiction. When a court has the original jurisdiction, that means they can hear the case first. The legislation again outlines which court will hear which case first. Let us go back to this table. Tell me, if we are dealing with a civil case where the claim is up to $40,000, which court will have the original jurisdiction in Western Australia to hear that civil case? The magistrate court. Okay, so the magistrate court heard that case and the defendant is very dissatisfied with the outcome of this court. Now the defendant wants to take the matter for an appeal. Which is the higher court he can go for an appeal? District court. So you see, for a claim up to $40,000, the original jurisdiction was with the magistrate court, but the magistrate court cannot hear its own appeal, right? The appeal will always go to a higher court. So in Western Australia, we have a district court. So district court will hear an appeal from a magistrate court. Say there is a litigation, civil case, where the claim is up to $80,000. Which court has the original jurisdiction to hear that case? District court has the original jurisdiction. The district court heard that case, gave a verdict, but the defendant is dissatisfied, wanna make an appeal. In which court that person can file an appeal? Supreme Court. So you see, based on where the case has been initiated, it will direct where it will take for the appeal. So that's what we mean by civil jurisdiction and appellate jurisdiction.
Can you appeal a Supreme Court?
Directly?
Yeah.
No, usually it's, if a case has been heard by a magistrate court, then it will go to its immediate higher court. That means the district court. We cannot bypass.
No, so if Supreme has it, case has been heard, they want to appeal it, can they do that?
In a Supreme Court, if someone wants to make an appeal, of course, someone can take the matter up to the highest court of Australia, that is the High Court of Australia. I have a separate slide on High Court of Australia, what type of powers the High Court of Australia has. We will go through it. But in the present court structure, High Court is sitting on the top and they can hear the appeal. But there is a difference. Let me explain that, though I was saving it when... No, I will talk about it when I explain the High Court of Australia, not now. But what I'm saying here, if someone, a case has started in a magistrate court, straight away they can file a case to the district court. With High Court, the system will be slightly different. I will make that point clear when we talk about the High Court of Australia. So from this first half of our discussion, we actually talked about three types of jurisdictions. The first jurisdiction was based on the territory. We have state and territory level court system, and we have federal court system. We have jurisdictions based on the subject matter. It can be a civil jurisdiction or a criminal jurisdiction. It can be based on who hears the case, which court is hearing the case. That's how there can be an original jurisdiction of a court, or it can have an appellate jurisdiction. So now I'm going to ask you guys, does a magistrate court have an appellate jurisdiction for a claim up to $40,000? So the claim is up to $40,000. Can the magistrate court hear that appeal? No, because it is sitting at the bottom. but the other courts, the district court definitely can hear that appeal. We will talk about that in a moment. So by this time, you guys have noticed that we are talking about which court is sitting at which position. There is a kind of invisible hierarchy working in our court system. I hope all of you have already felt that, right? In Australia, the court system, the way it functions, based on this hierarchy of the court system. And again, we have inherited this concept of courts hierarchy from English court system. So why hierarchy is so important in our court system? The court's hierarchy provides this structure. It provides a very clear picture to everyone, not only to the lawyers, not only to the parties. They know, okay, if I want to file a case, in which court I must go first, which court has the original jurisdiction. That is determined by the court's hierarchy. Where I can go for an appeal, again, that is determined by the court's hierarchy. So court's hierarchy actually allows the hearing of the appeal. That is the most important thing you need to remember. If a defendant or a plaintiff or a prosecutor is dissatisfied with the outcome of any trial, he or she has the automatic right to appeal to a higher court. Keep in mind, I'm repeating it. If someone is dissatisfied with the outcome, they have the automatic right to appeal against that case in a higher court. This provides, the courts to hear a matter once again, and if there is any mistake, that can be resolved. And so whichever court has that appeal power, has that appellate jurisdiction, only then they can hear that case. There are few other implications of having this court's hierarchy. The other one is a building precedent. I will be delivering a lecture after the break during the second half of today's lecture on precedent, and you will see the concept of precedent, which actually has helped us to come up with this common law legal system, is based on court's hierarchy. Not every court will be capable to create precedent. Only a higher court is capable to create a precedent which is binding on the lower courts. So this concept of courts hierarchy has a bigger role to play in Australian court system. Okay, so now I will be talking about all different courts based on their hierarchy at the state level as well as federal level. Okay, so at the state level, we need to know about 3 different types of courts. First one is sitting at the bottom. They are known as the inferior courts. Then we have intermediate courts sitting in the middle, and then superior courts sitting at the top level at the state level. So all these 3 types of courts all together known as a court system. Okay, we call them state and territory court system, and I will go through each of these courts now. I will be talking about the criminal jurisdiction and civil jurisdiction of the inferior courts. I will go through the criminal, civil and appellate jurisdiction of intermediate courts, and I will do the same for the superior courts. So that then you will get a clear view. In Western Australia, I will be paying more attention on Western Australian courts. Which courts got what type of civil jurisdiction, what type of criminal jurisdiction, does it have an appellate jurisdiction or not, right? Though I'll be paying more attention on WA courts, at the same time I will be referring to other jurisdictions so that you know how the court system is different in different jurisdictions, different states, different territories. They have slightly different structure, but more or less it's the same. So let's start with the inferior courts. They are the lowest courts in the state court hierarchy system. These courts are known by a different types of names. For example, in Western Australia, we call them as magistrate courts. But that's not the same for all other jurisdictions. For example, in New South Wales, they call their inferior court as local courts. Okay? So in my lecture, I will be referring these lower courts or inferior courts as magistrate courts. Why? I'm paying more focus, more attention to WA. In WA, they are known as magistrate courts. Does it make sense? But that doesn't mean in New South Wales they call them as a magistrate court. No, they call them as a local court. So inferior courts are presided over by magistrates. or in some cases, in some states, even justice of peace can sit in a magistrate court and hear a case, but no judges. At this lower level, judges do not sit and hear any case. Only magistrates will hear in an inferior court or in magistrate court in WA, right? So they have both types of jurisdiction, civil jurisdiction and criminal jurisdictions. So I just added this image just to show that local courts, inferior courts, they are available at local level. Like in Joondalup, we have a magistrate court, for example. But we will not have a district court in Joondalup. District courts are mostly in the cities. In Perth, we have our district court in Perth City. In other states, they have their district court in their cities as well, not at a local level. So let's focus on the civil jurisdiction and criminal jurisdictions of a magistrate court. I think by this time you already know the civil jurisdiction. Let's talk about the criminal jurisdiction first. So magistrate courts, that's where the cases starts, right? So when we're talking about the criminal jurisdiction of an inferior court, we will start with minor cases. For example, minor criminal offenses which are less serious in nature, like someone has failed to pay traffic fines. That's an offense, right? That's a crime. Someone was drink driving, someone did shoplifting. Those type of crimes, again in the statute, the criminal code, they are known as simple offenses. Especially that's a legal term, and that's why I have highlighted in a different color. So simple offenses in Western Australia, like the examples as you can see, shoplifting, drink driving, those type of things, they will be tried in a magistrate court in Western Australia. And the whole purpose of hearing these cases is, to resolve the matter as quickly as possible. So most of the time you will see in a magistrate court, the cases are not going through a very lengthy procedure. It's a summary trial, they say. Very quickly they come up with an outcome. That means there is a fine or something like that that will be imposed, and very quickly the case will be resolved. Whereas, more serious matters, if the stealing, breaking, entering onto the property, those type of offenses, they are known as indictable offenses, which the magistrate court can resolve the matter, but it depends on the severeness of the case. Then they can refer the cases to a higher court. If the crime is very serious in nature, like murder, manslaughter, armed robbery, rape, fraud, those type of serious crimes, what will happen? The magistrate court will never hear those cases, but they can do a preliminary investigation. So the proceeding that the magistrate court will start for those severe or serious cases is known as committal proceeding. That means the magistrate court will do a primary investigation and will try to come up with an outcome. What could be the outcome based on the primary investigation of the magistrate court? They may find that there is no merit in that case. Someone has accused of any fraud or robbery, but there is actually no truth into it. Based on their first investigation, they can dismiss the case. That's the power the magistrates have. Or if they find any merit into the case, what they will do, they will prepare a report and they will refer the case to a higher court. For those serious crimes, the magistrate court will never hear the case. They can't. They do not have that jurisdiction. They will refer the matter most of the time to the district courts. Does it make sense? So these are the criminal jurisdictions a magistrate court in Western Australia they have. If it is a simple offence, they will hear the case, they will come up with a punishment or something. The procedure they follow, it's a summary procedure, it's not that detailed and thorough. There can be some offences which are indictable offences. They are known as either way offences in Western Australia. The magistrate courts, they can decide to hear the case or refer the matter to a higher court. But if the crime is very serious, the magistrate court will start the committal proceeding. That means they will do the primary investigation. Based on that committal proceeding, they can refer the matter to the higher court for a thorough investigation, for a full trial. Does it make sense? Any question regarding the criminal jurisdiction of a magistrate court? Though we will not cover any criminal case in this unit, I'm just sharing this as a foundational knowledge so that we understand how criminal jurisdiction is different from a civil jurisdiction, right? We already have explained the civil jurisdiction from table 2.1. In Western Australia, the magistrate court, the inferior court, they have the jurisdiction to hear the case if the claim of that civil case is up to $75,000. But that is not the end of a civil jurisdiction of a magistrate court in Western Australia. Claims for minor cases and with less formal processes, if there is any debt involved, someone needs to recover the debt, then up to $10,000, that case will be heard by the magistrate court. If there is any damages where, again, the jurisdiction, the legislation says the power or jurisdiction of the magistrate court is up to $10,000, not more than that. So that's about the inferior court. But when we are talking about the intermediate court, they are sitting in the middle of the court's hierarchy. Again, we'll be talking about their criminal jurisdiction, civil jurisdiction, but something extra. So these intermediate courts, they have appellate jurisdiction as well, right? And in Western Australia, we have our district court. So these intermediate courts, again, they have different names in different jurisdictions. In Western Australia, we call them district courts, but that doesn't mean that all the states have a district court. For example, Tasmania, they do not have a district court, okay? In Western Australia, we call them district courts. In Victoria, they call them as county courts, okay? So they have different names based on what jurisdiction. But in my lecture, I will be referring them as district courts. Why? Because we are in Western Australia. In Western Australia, the intermediate courts are known by this district court, by this name. So 8 jurisdictions, if you recall, I mentioned 6 states and 2 territories, right? Out of these 8, only 5 jurisdictions, they have an intermediate court in their court's hierarchy. Tasmania doesn't have an intermediate court. The 2 territories, ACT and Northern Territory, they also don't have an intermediate court. So they have their lower courts and their supreme courts. That's how those jurisdictions function. Now, criminal jurisdiction so the criminal jurisdiction, the magistrate court, when we discussed about the magistrate court's power, we already have mentioned that if there are more serious offences, the magistrate court in WA, they will not hear those cases. Those cases will be referred to the magistrate court. So whatever cases have been referred by the magistrate court will hear those cases. So for any criminal matter, intermediate courts, they deal with bulk of indictable offences. And when the intermediate court is hearing any criminal case, there will be a judge. Not only a judge, for any criminal case, there will be a jury of 12 people. And jury mostly, picked from the society. So you recall that I said that the law considers the crime has happened against the society, against the community. So when the intermediate court is hearing a criminal case, not only the judge is sitting there, the jury who represents the community, they are sitting as well. So the state party who has brought the case against the accused person, they must convince the jury beyond reasonable doubt that this person, accused person, has committed the crime. So that's what happens in an intermediate court when they are dealing with the criminal jurisdiction. Regarding civil jurisdiction, we already have mentioned based on this table, you already know, in Western Australia, what's the civil jurisdiction. For a district court, it's between $75,000 to $750,000. But the intermediate court also have an appellate jurisdiction. So this court hears appeal from the magistrate court. So this is something new. That's the magistrate court, they do not enjoy that power or that jurisdiction. Okay. After the intermediate court, now let's talk about the superior courts. At the courts hierarchy at the state level, superior courts sit at the top, and they also have a criminal jurisdiction, civil jurisdiction, and appellate jurisdiction from the lower courts, right? So superior courts, they also have different names in different jurisdictions. In most of the states, they are known as Supreme Court. In Western Australia, we have Supreme Court of Western Australia. In New South Wales, they have their own Supreme Court of New South Wales, Supreme Court of Tasmania, etc. Northern Territory and ACT, these are the two territories. They also have their Supreme Court. The Supreme Court has its civil jurisdiction. As you can see, there is no limit. In WA, the Supreme Court of WA, if the claim is for a civil case, if the claim is above $750,000, then it goes to the Supreme Court of Western Australia. So there will be no jury, but that's how they enjoy their civil jurisdictional right. But for criminal jurisdiction, the Supreme Court will hear only the most serious cases, for example, rape cases, murder cases, and again there will be a judge and a jury of 12 involved when a Supreme Court is hearing a criminal case. This is this has its appeal jurisdiction as well. So in Western Australia, the Supreme Court of Western Australia, they can hear any case that was determined by the district court. If the parties are dissatisfied, they can take the matter to the Supreme Court. Victoria, New South Wales, Queensland, Western Australia, ACT and Northern Territory, they have their Supreme Courts. They enjoy the appellate jurisdiction. The other one, the Tasmania and Victoria, their Supreme Court, they do not have the appellate jurisdiction. So I am focusing on Western Australia, and as you will see that we have magistrate court at the bottom, we have district court in the middle in Western Australia, and we have Supreme Court with the appellate jurisdiction sitting at the top in our state court system. So that's in a nutshell. This is an image of the Supreme Court of Western Australia. That's in a nutshell about the state court system. Happy to take any question regarding the state court system before we start talking about the federal court system.
I've got a question.
Yes.
Reading we had previously, there was a ruling where similar to South Australian company, where they supposed to have a license and such, but this is kind of going to the previous lecture. I'm not sure how it ties into this. So if there's a case between like what's a federal law or legislation or state law, how do they start? Because I understand if you've got like an appeal, you go like up the way, but how does it work between the federal?
That's a good question. Let me start explaining this concept based on last week's lecture. So last week we talked about the division of power between Commonwealth and the state. So based on that division of power concept, we know that our constitution has made it very clear regarding which matters the Commonwealth or the federal, they will be able to make law. And the federal courts will be able to apply those laws, right? The law that is at Commonwealth level, the state courts can't apply that, right? So the Constitution has clearly outlined what are the specific areas, say currency, military, tax. Those are the areas where the Commonwealth will enact law and apply those laws via federal courts. At the state level, the Constitution again clearly mentions for which area the states, they have their lawmaking power. In those areas, the states will make their own legislation and they will apply those acts, legislation or statutes, via their court system at state level. Does that answer your question?
Yeah, it does.
Okay. You can apply, so from there, I spin the name, and if you go to a state court, so you get done for a traffic offence of drink driving, you can appeal to the state court for a spent conviction under the fact that you will then go back to the Defence Force and get charged under the Defence Force Disciplinary Act. So then you don't get that criminal charge, but you still get the punishment is worse. Probably fair to just lost my licence.
Thank you. that brings us to the discussion of the federal court. Let's learn about those federal courts, which federal courts we have, and what type of, authority or what type of power they can exercise. So in our federal court system, we have broadly 3 courts. The first one sitting on the top, the High Court of Australia, right? We all can see the green one on the top. The next one I'm going to focus on is sitting at the bottom, Federal Circuit and Family Court of Australia, FCA. It has some background. Previously, there were 2 separate courts. They had their, Federal Circuit Court, that was a separate court, and Family Court was a separate federal court, but they put them together. I think that happened very recently, from 2021. The Federal Circuit Court of Australia and the Family Court of Australia have been merged together into one court, and now they are known as the Federal Circuit Court and Family Court of Australia, Federal Circuit and Family Court of Australia. So this is a very recent development. During my lecture, what I will do, I'll be talking about the historical background, how these courts were separate, how and when they were built, and what type of jurisdictions they used to enjoy. Again, I will be talking about the present day scenario as well. So on the top, the High Court of Australia is sitting there, and at the bottom, Federal Circuit and Family Court is sitting there. What's in the middle? We can see Federal Court. This one, as it enjoys its original jurisdiction where only a single judge will see it and hear the cases. And again, it has specific powers that the Federal Court can hear the cases. But this one is a full court of federal court when it enjoys its appellate jurisdiction. When it is hearing its appeal, then all the judges that sitting in the federal court, they will sit together. It's not a single judge. Single judge is not hearing a case. So in that sense, it may look like 4 different courts, but no, basically it's the 3 courts we are talking about. High Court of Australia, then in the middle, Federal Court, and the third one is Federal Circuit and Family Courts of Western Australia. These are the 3 federal courts we have in Australia. Now, let me, raise a red flag. The court system that we are talking about is known as Federal Court System. Under that Federal Court System, we have a specific court. The name of that court is Federal Court. I'm raising the red flag. Why? It's very easy to get confused. If the question says, explain the jurisdiction of the federal court, you need to pay attention to this federal court only. Okay, what do you mean by a federal court? What are the powers or jurisdiction this federal court have? When it is a single judge sits in a federal court, what types of authority they have? When the full bench sits, what type of authority they will exercise? So that's all about the federal court. But if the question asks you, explain the federal court system of Australia, what you are going to explain then? Whole lot. You're absolutely right. We have to talk about High Court. We have to talk about the Federal Court. We have to talk about Federal Circuit and Family Court. So all these 3 courts together makes the Federal Court System. So read the question very carefully, because this is a very confusing, question. If it asks you explain Federal Court, explain the jurisdiction of Federal Court, then you are paying attention only on one court. Whereas if the question asks you Federal Court System, then you have to explain all 3. Now, when I was sharing the lecture slides with you, I guess I have shared the old federal court system, the slide. I'm not sure whether I have updated it. Yeah, you may find this one in at your end when you are going through the lecture slides. Okay, my apology that I didn't upload the student version. But if you go to your textbook, figure 2.7, you will see that this image is not available. The image that I'm sharing with you now, that's what in your latest edition. So my apology if in your lecture slide still I have this slide, my apology. But again, let me explain you how this one was working. You see the High Court, it's sitting on the top. You see the Federal Circuit Court of Australia, FCCA, that is sitting at the bottom, and you see Family Court here, and you see Federal Court there. So before 2021, we used to have these 4 federal courts under our federal court system. This image will still help us to understand, because what happened from 2021, this Federal Circuit Court and this family courts, they have been merged together. But it has 2 divisions. That one court, Division 1 and Division 2, that's how they divide their work. So they have been merged together, but function-wise, jurisdiction-wise, they are doing the same things, though there is one of them have been abolished, and out of 4, we have only 3 court system. The other courts, you can see here, these are the full courts where they are enjoying their appellate jurisdiction. So the full court of the federal, this is the one sitting here. The full court of the family, when they hear any appeal, then they sit in a full bench. That's how it works. So that is the old federal court system. My apology, I forgot to delete it from your lecture slides. Yes, my dear, you had a question.
Oh, no, it's fine. I was just, you basically
Okay.
answered my question.
Okay, so let's go through the federal court system, and I will explain each of these 3 federal court system one by one. So first, let's start with the Federal Circuit Court. On this slide, I want to start with the Federal Circuit Court as it was known before 2021. So what happened in year 2000, Australian Commonwealth, they have established this federal court, which was known as Federal Circuit Court of Australia. Now, in the present day scenario, after 2021, we do not call it as Federal Circuit Court of Australia. We have merged it with the Family Court, right? So why in year 2000, Commonwealth established a separate court? Because we had the Family Court. Historically, we already had the Family Court as part of our federal court system, right? But Family Court was so overwhelmed, overburdened with family cases. To help the Family Court, the Commonwealth actually created this Federal Circuit Court of Australia. So Federal Circuit Court used to look after almost 95% of migration-related cases. So that is the jurisdiction, that was the jurisdiction of the Federal Circuit Court of Australia. Any migration-related litigation, industrial law, any minor family matters, they used to hear. Almost 80% of family law-related cases used to be heard by the Federal Circuit of Australia. So that used to be its jurisdiction, but as we know, from September 2021, it has been merged together with the Family Court. So before 2021, we had a separate family court, and that court was established under this Family Law Act. What do we refer by court of record? In a moment, I will come back to that topic, not now. So what the Family Court used to do, definitely family-related issues, they used to hear the cases, right? So if there is any divorce case, any custody-related case, all those cases used to be heard by Family Court. Why? Again, the Constitution of Australia gave that power to the Commonwealth. That's why Commonwealth created this Family Court, and the Family Court used to hear all those cases. But so many cases that Family Court was very much overwhelmed. That's why in 2000 Federal Circuit Court was established. Ultimately in 2021 these 2 courts have been put together again under this combined system. Federal Circuit Federal Circuit and Family Court, they have their 2 divisions, Division 1 and Division 2, and they kind of follow the same structure, but it's just not 2 separate courts anymore. It's just 2 courts merged together. That's how. But still, they follow the same, they enjoy the same jurisdiction. Any minor family-related matter, migration-related matter, industry law matters, consumer law, competition law-related matters, all those things will be looked after by Division 2, whereas Division 1 will be looking after the more complex family law-related matters. Any questions so far? This is the first federal court we are talking about. The next one is the Federal Court of Australia under the federal court system. Okay, it's sitting in the middle. So this court is the approximate equivalent of the state court system. So at the state level, we had magistrate court, intermediate court, district court in WA. We have Supreme Court, right? And it had a criminal jurisdiction and civil jurisdiction. At federal level, at Commonwealth level, this federal court has the jurisdiction, the original jurisdiction, to hear any criminal cases or civil cases, but those cases must be based on Commonwealth law, okay? So say if there is any act of terrorism, this is a crime, right? If there is an act of terrorism, can a state court, say Supreme Court or district court or magistrate court, can it hear that case? No, because terrorism is such an area which Commonwealth law will be dealing with. That's why that criminal case will be heard by Federal Court of Australia. Does it make sense? Okay. So if there is any immigration related dispute, any custom taxation, for example, taxation, it's a civil case, right? Taxation is a civil case, but if there is any dispute that I have not paid my tax this year, can that case be heard by any court in WA, any state courts? No. So at the state level, if you recall last week when we talked about division of power, the Australian Constitution has divided the power, which areas the Commonwealth will look after and make the laws, and which areas the state will look after, make their own laws and apply by their court system. This is what's happening at Commonwealth level. So federal court is actually dealing with the civil cases and criminal cases at Commonwealth level. Does it make sense? Okay. The federal court, when it has its original jurisdiction, as you can see, I have listed if there is any case related to bankruptcy, copyright, competition, it's a big list. They can exercise their original jurisdiction. That means the federal court will start the case. But at the same time, if the federal court will have a single judge to hear that matter. If anyone is dissatisfied with that judgment from the single judge, that matter will be taken to the full bench, full division of the federal court. The full division of the federal court will exercise their appellate jurisdiction. Does that make sense? That's what we have mentioned here. All these jurisdiction, tax-related, bankruptcy-related, consumer law-related disputes will be heard by a single judge. That's the original jurisdiction. But if there is someone who is dissatisfied, they can make an appeal to him, to the full bench, full court of the federal court. Then all the judges at the federal court, they will hear and sit and give an appeal verdict. Now the next one we are going to talk about is the High Court of Australia. So again, Australian Constitution in section 71 mentioned that we will have a High Court, and based on that section 71, Commonwealth established the High Court of Australia. It has its original jurisdiction, it has the appellate jurisdiction. Let's talk about all those things. So this court only hears the most important cases. So if we talk about the original jurisdiction of the High Court, if it is any civil case or criminal case at federal level, usually it is heard by the Federal Court of Australia, right? They have their original jurisdiction at Commonwealth level. Still, High Court has some original jurisdiction. High Court is the most important court, right? We want to take only the most important matters to this court. If there is any dispute between the two states, say WA and New South Wales, they got into a dispute. Which court will hear that case? The High Court of Australia will hear that case. Say we have the Constitution of Australia, right? This is the highest document, highest piece of legislation. If there is any conflict, if government requires any direction based on the Constitution, which court can explain our Constitution? the High Court. They have the original jurisdiction to resolve those matters. High Court has its appellate jurisdiction as well. So Federal Court heard a full bench of the Federal Court heard an appeal. But if the dissatisfied parties want to make an appeal, they can take the matter up to High Court of Australia. But as I said, at the state level, when we are talking about appeal jurisdiction, we said as of right, matters can be taken to a higher court, right? But we know High Court of Australia is the highest one, and it is so such a place where only the most important cases will be heard. So there is an extra level of hearing this appeal. So if a litigant wants to take a matter to the High Court for appeal purpose, there will be a pre-hearing. That hearing is known as a special leave to appeal. Only after that hearing, if the judges are happy that this case has a merit, that the High Court full bench will sit and hear that case, only then the High Court will hear the case and will exercise this appellate jurisdiction. So it's not as of right someone can take the matter to the High Court. And again, this is because of ensuring that the High Court is dealing with only the most important cases. So far I have talked about the original jurisdiction, appellate jurisdiction, civil jurisdiction, criminal jurisdiction, all those things. But on all those slides, I hope you have noticed that I have mentioned a court of record. I have mentioned some courts are known as court of record. What is that? When we'll be talking about, we'll go for a break now, and after the break, when we will come back, you will see that we will be talking about this court of record. So only the court of records, they are capable of making precedent. And those are, most of the time, the higher courts, and those precedents are binding on the lower courts. That's how it works. So I'm not going to explain it now, but I'm just showing you some of the courts have this power of court of records. They can create precedent, and other courts like magistrate court, they cannot create any precedent. Does that make sense? Any question? If not, I had a long lecture, so let's go for a break, and after the break